but it does give me great pleasure to introduce a very old friend of mine, Mr. Justice Rothstein. We met at a tiny college on Portage Avenue in Winnipeg in 60 years ago, and it's a tribute, I think, to our friendship that even though we've mostly lived in different cities for the past half century, we're still very good friends. And I was excited when he was appointed to the federal court, and I was even more excited to be at the Supreme Court of Canada, the only time I've been in that chamber, when he was sworn in. And then from time to time, delighted to come very early in the morning to the side door and have early morning coffee in chambers. And most of all, I enjoyed his retirement party, the speeches given by his children and his grandchildren, and particularly the Chief Justice, who said something that all of us who have known Marshall have known. He's really a hard worker. What we used to say is he billed New York hours in Winnipeg. And now he's made the decision to move to a brand new city where he's never lived before, Vancouver. And again, he has to have billable hours. And he's got a managing partner he reports to. Now, isn't that a beggar for punishment? But he's taken time out from his billable hours to be with us today, so I ask you to welcome him.
Don't worry, it's triple space. So my remarks come at the end of a very full day for all of you. There's the story of the guy who got up to speak in the late afternoon at a conference, and people started to stand up and file out, and eventually there was only one person left in the room. The speaker said, "I put a lot of work into my presentation, and I'm really happy you stayed. You must be very interested in my topic." And the guy said, "Are you kidding? I'm the next speaker." So I know I'm the only thing standing between you and a drink and dinner, but I'll still be watching to see who stands up and files out. I was listening to the questions you asked of the last panel. You're all experts here. I just want you to recognize that the Supreme Court is a generalist court, and so go easy on me when the time for questions comes. Well, thank you, Joe, for your generous introduction. I should say, though, that your sentiments are not universally held. One day, when I was still at the court, I went to the office. My wife, Sheila, had asked me to remove the bed linen that day, which I thought I had done before I left. Email, Sheila Rothstein to Justice Rothstein, 10:53 a.m. "I told you to remove all the linen, including the blanket cover. You did not listen to my instructions and only did half a job. I hope you do your legal opinions better than removing the linen from a bed. When you come home, you will make the bed all by yourself." I'm always grateful that speaking against that Sheila isn't the one to introduce me. But some things haven't changed since I left the Supreme Court. I got coffee at Starbucks on my way to the office in Ottawa, and I still do in Vancouver, in addition to having coffee before I leave in the morning. Email, Sheila Rothstein to Justice Rothstein. "Get fruit." Justice Rothstein to Sheila Rothstein. "What fruit?" Sheila Rothstein to Justice Rothstein. "Berries, grapes, and nectars." Justice Rothstein to Sheila Rothstein. "Nectars are out of season and not available, and grapes are expensive, but I'll get them. Berries are too expensive." Sheila Rothstein to Justice Rothstein. "If you didn't waste money at Starbucks every day, you would be able to afford berries." She always gets the last word. Well, today I have to start with a disclaimer. My title, The Supreme Court and the Redevelopment of Social Corporations, may suggest that it's the court that has developed legal doctrine that restricts the way in which a corporation as a legal entity may behave. And if I've given that impression, it would be wrong. Judges create what we call the common law that originates in judge-made rules and develops over time as successive generations of judges tweak and adapt the common law to new circumstances. Although the laws around negligence and contract are generally common law, there are also many relevant statutes. Over the years, the courts have modified and updated these areas of the law. But to a large degree, the legislatures in common law countries such as the United Kingdom, the United States, Canada, and other countries whose laws derive from the British system have taken over many areas of the common law. They have created rights and obligations that were either never or only haltingly considered by judges in the courts in the past. Today, I would guess that the vast majority of the laws that we have, perhaps 90%, are laws made by the legislatures. And it's the role of the courts to interpret the statutes created by Congress, Parliament, and the legislatures. To me, judicial interpretation of statutes is not common law, but this is where the debate often rages about courts being activist in their interpretation of statutes and constitutions in Canada and the United States. Corporations initially, as you know better than me, were created by royal charters issued by the king. And you were talking about the Hudson's Bay Company, who received its charter from King Charles II in 1670. And over the years, corporations came into existence more by public statutes, at least in Canada. So the banks, the railway companies, insurance companies, and other large corporations were created by acts of Parliament. And they still are to some degree. But in recent years, I'll say within the last 100 years, corporations have been largely created administratively under the Corporations Acts of Parliament and the legislatures of the provinces. In Canada, corporations that came under federal jurisdiction, like banks and railway companies, interprovincial railway companies, were created under federal corporation laws. Corporations that came under provincial jurisdiction were formed by articles of incorporation under provincial corporations acts. And these federal and provincial corporations acts place certain obligations on corporations and their directors. Statutes other than the corporations acts that imposed restrictions and limitations on corporations and individuals included consumer protection legislation, labor legislation, human rights legislation, and so forth. So courts have not imposed their own freestanding judge-made rules on corporations, but rather interpreted the statutory rules created by the legislatures. Sometimes the courts read the statutes narrowly, sometimes more broadly. It is the court's interpretation of these statutes that contoured and defined the legal obligations owed by corporations that I will talk about. And so it's in the way the courts interpreted those statutes that will largely be the subject matter of my remarks this afternoon. And I propose to deal with 5 areas of law involving the modern corporation that the Supreme Court has dealt with over the last 10 to 15 years. 1, duty of directors. 2, class actions against corporations. 3, punishing corporations. 4, tobacco advertising. And 5, transfer pricing. I'll start with the duty of directors, duties of directors. Are their duties solely to maximize value for shareholders, or do they have a broader duty to other stakeholders like debenture holders, employees, customers, the environment, and even perhaps the government? For this part of my remarks, I have plagiarized shamelessly from an article written by lawyer Robert Milnes in the 2009 issue number 24 of Banking and Finance Law Review at page 602. The article is written about a well-known but ultimately failed takeover of BCE, the parent company of Bell Canada, the largest telecommunication company in Canada. Until the early part of the 20th century, directors were considered to be trustees, and their duties and powers developed out of that concept. But there is one important difference between the role of trustees and the role of directors. Trustees are expected to adopt a conservative management policy to preserve the assets for the beneficiaries of the trust. Directors are charged with the responsibility of managing the assets in such a way as to maximize profit and value for the shareholders. One of the most important duties of directors is to act in the best interests of the corporation, which is now a statutory duty under the Canada Business Corporations Act. But what does that mean? How can you act in the best interests of an inanimate object like a corporation? Well, traditionally, acting in the best interests of the corporation has been interpreted as imposing a duty on directors and officers to always act only in the best interests of the shareholders, essentially to maximize the earnings and value of the corporation. Directors who considered the wider interests of the community in making decisions such as environmental decisions, labor and employment issues, or human rights issues did so at their own risk, especially if the economic interests of the shareholders were ignored or took second place to the other interests. In the U.S., the courts have held that directors will be in full compliance with their duty if they consider only maximization of value for shareholders, particularly in the context of a takeover bid. The leading case in this regard is referred to as the Redevelopment case in 1986, a decision of the Delaware Supreme Court, which will be familiar, I'm sure, to many of you. Well, in Canada, in 2004, the Supreme Court considered whether or not the duties of directors could be extended to creditors in the case of People's Department Store versus Wise. In People's, the directors of a department store chain implemented a cash management system among affiliated retail entities, which resulted in the insolvency of the entire corporate group. Creditors of the corporate group sued the directors personally. They were unsuccessful, but the court held that the statutory duty of care imposed on directors will enable any outside party injured by failure to meet this duty of care to sue for damages, including creditors. On this principle, creditors could bring an action for breach of the statutory duty of care should directors act recklessly and not with a degree of skill expected of them in the particular circumstances. Well, in the People's case, the Supreme Court said that in a modern corporation, the directors, in acting in the best interests of the corporation, are entitled to consider the interests of other important stakeholders, such as employees, the community, suppliers, consumers, governments, and creditors. Even though the Supreme Court found that the directors of People's acted in good faith and were not liable to People's creditors, the analysis by the court opened the door for creditors to sue directors for their losses. The next case, BCE, provided circumstances for the application of these new principles. For many years, the share value at BCE had not reflected its full potential as a modern telecommunications enterprise, and BCE received overtures from various private equity firms to take it private. On April 9, 2007, BCE was formally put in play after the consortium headed by the Ontario Teachers Pension Plan Board filed a report with the U.S. Securities and Exchange Commission advising the market that its investment intent with respect to BCE had become active. At the time that BCE came into play, its main operating subsidiary, Bell Canada, had debentures outstanding in the amount of $7.2 billion. These debentures were classified as investment-grade bonds by various rating agencies and therefore were held by many of Canada's leading financial institutions, pension funds, and insurance companies. All of the debentures had been issued under trust indentures containing covenants for the protection of the debenture holders. On June 29, 2007, BCE signed a definitive agreement with the Teachers Group for the acquisition of all of its common shares at a price representing a 40% premium over the then market price of the BCE common shares. The transaction was to be completed by way of a plan of arrangement under the Canada Business Corporations Act, which required both shareholder and court approval. It was a leveraged buyout whereby the teachers' group would incur an enormous amount of debt to fund the acquisition secured by the Bell assets. The plan of arrangement was approved by 98% of BCE's common shareholders, but before it could be consummated by court order, the debenture holders filed an opposition to the issuance of final approval. This was on two grounds. One, that the plan of arrangement would fundamentally alter the investment characteristics of the Bell debentures, resulting in a significant downgrading in their rating and value of these investments. And second, the plan of arrangement would materially increase the risk of default by the significant debt, approximately $34 billion, being assumed by Bell in guaranteeing the indebtedness being incurred by the teachers' group to fund the takeover. Well, remember that the amount of debentures outstanding prior to the proposed acquisition was only $7.2 billion. The problem for the insurance companies and pension funds that held Bell debentures was that they were required to hold only investment-grade securities. When the proposed leveraged buyout was announced, the market value of the debentures declined by more than 20%. Their concern was that they would be required to divest their below investment-grade debentures at a substantial loss. Well, the Quebec Superior Court approved the leveraged buyout. The Quebec Court of Appeal overturned the Superior Court, and the case then came to the Supreme Court of Canada for final resolution. I was not at the Supreme Court at the time of the People's case, but I was there at the time of the BCE case. However, I recused and did not sit on the case. My family and I had at least what for us were significant investments in BCE debentures and the shares of a number of the insurance companies that were contesting the takeover. Our holdings were for us too significant to divest, so I would have been in a conflict of interest to have participated in deciding the case, as our interests were aligned with the debenture holders and against the interests of the common shareholders of BCE. The decision was therefore rendered by my colleagues at the court, and the Supreme Court did overturn the Quebec Court of Appeal and approved the takeover. The effect of the decision is that it requires boards of directors to consider in a fair and equitable manner the interests of all the stakeholders affected by a particular corporate transaction and not just the interests of the shareholders, and then decide based on their view of the best interests of the corporation as a whole. Well, it won't take you long to realize that this places the directors in a difficult position. If the interests of the debenture holders is directly opposed to the interests of the common shareholders, as in the BCE case, how do the directors resolve the conflict and decide not on the basis of legal rights, but on the basis of fairness and equity? What was invoked by the debenture holders what is known as the oppression remedy in the Canada Business Corporations Act. Traditionally, it was thought that the oppression remedy was a remedy for minority shareholders and corporations whose interests were being sacrificed by the actions of the majority shareholders. This would normally arise in the case of private and probably smaller corporations, and there it is easier to grasp how fairness and equity might be considered as between majority and minority shareholders. However, in BCE, the Supreme Court stated that this suppression remedy focused on harm to the legal and equitable interests of a wide range of stakeholders. The remedy is in fact specific and based on the concept of fairness in determining whether or not the remedy will apply. A wide reading of the oppression remedy indeed. Two questions must be considered by the court. First, is there evidence of a reasonable expectation on the part of the stakeholder? And secondly, was its reasonable expectation not met because of oppressive behavior on the part of the corporation and its board of directors. The failure to meet the reasonable expectations of the claimant must involve oppressive or unfairly prejudicial behavior or an unfair disregard of the interests of any stakeholder. In the BCE situation, the debenture holders claimed that they had a reasonable expectation that the investment-grade trading value of their debentures would be maintained at all times. The Supreme Court said that although Bell Canada, over the years, had suggested in public statements a commitment to retain investment-grade ratings for the debentures, such statements were also accompanied by warnings precluding such expectations. The Supreme Court also pointed out that the debenture holders could have protected themselves with covenants dealing with their rights on a change of control, since, given the nature and corporate history of Bell Canada, it would not be beyond the contemplation of sophisticated investors, such as the pension funds and insurance companies, that a buyout transaction could well occur. With respect to the second question, whether or not the violation of the debenture holder's reasonable expectations was caused by oppressive behavior, the Supreme Court held that the directors complied with their duty to resolve conflicting interests of stakeholders arising from the leveraged buyout situation by determining what was in the best interests of the corporation. The Supreme Court accepted the evidence that BCE needed to undertake significant changes to be successful, and that then current market conditions made a buyout inevitable. As such, for the Supreme Court, the fact that one group of stakeholders, the shareholders, is favored over another class of stakeholders, the debenture holders, as a result of the directors exercising their discretion, does not mean that the directors did not act in the best interests of the corporation as a whole, especially when conflicting interests between the two categories of stakeholders could not be resolved to everyone's satisfaction. And finally, in BCE, the Supreme Court has referred to the fiduciary duty of directors to act in the best interests of the corporation, viewed as a good corporate citizen. While it's unclear from the decision whether the Supreme Court is adding a new standard in assessing whether a fiduciary duty has been properly performed, namely, whether or not the best interests of the corporation must always be viewed in the context of the corporation being a good corporate citizen. This wording seems to suggest something circumscribing the best interests of the corporation by the concept of good citizenry, but it will require further judgments from the Supreme Court to verify what is meant by this phrase. So the Court, in what might be called a progressive approach, has now imposed duties on directors that go beyond the interests of the shareholders and require taking into consideration the interests of others. Because I didn't sit on the case, I feel quite at home to criticize the decision. In my view, the Revlon approach, the U.S. approach, saying that the director's duty to the corporation means duties to the shareholders, is simple and direct. Introducing concepts of fairness and equity in this context seems to me to create confusion and uncertainty not welcome in the business world. I must say it seems that in the end, as if the Court did really look at the contractual position of the debenture holders. And since the debenture covenants did not give priority to the outstanding debentures over new indebtedness that would be incurred for purposes of the buyout, it didn't seem like much of a stretch to favor the shareholders over the debenture holders. It was just a matter of considering whether there were legally enforceable rights, which there were not for the debenture holders. That is simple enough. Introducing concepts of fairness and equity seems to me to create unnecessary uncertainty. Well, to complete the picture, I've told you that this dispute between the debenture holders and the directors commenced in June 2007. You'll remember the financial meltdown in 2008. The transaction was to be completed at the end of 2008, but with that financial meltdown, telecom values declined, and there was a concern that the assets of Bell might not exceed its liabilities. In addition, the market declines likely increased the company's pension liabilities, and built into the agreement for the takeover was the requirement for a solvency report, essentially to ensure that there would be no lawsuits from bondholders due to the debt-laden capital structure of the corporation. Because of the deteriorated market conditions, the auditors engaged to provide the solvency report declined to do so near the end of 2008, causing the transaction to collapse. Happily for me and my debentures. However, that didn't preclude the spilling of much ink and the creation of some new and perhaps confusing law with regard to the duties of directors. I'll turn next to consumer protection and class actions. Well, over the last 30 years or so, legislatures in Canada have enacted class proceedings legislation that favors consumers against corporations. An objective of class actions is to provide a means by which plaintiffs with serious claims, but for whom it would be prohibitively expensive to bring legal action individually, could, using the power of their collective resources, bring a claim that would afford them an opportunity to obtain relief. Class actions are intended to promote the objective of access to justice. With that objective in mind, the courts, led by the Supreme Court, made it very easy to embark on and proceed with a class action lawsuit. There are statutory criteria that have to be met. For example, that there be an identifiable class, that is, that the class members had the same cause of action and suffered the same type of damages. The process involves a judge looking at the criteria for class actions and certifying the case as a class action if the criteria are met. And at least in Canada, the test for certification is very, very easy to meet. In Canada, class action legislation has been interpreted by the Supreme Court, therefore in a very favorable way to consumers and consequently unfavorable to corporations. In order to get a class action certified, the class plaintiffs only have to show some basis in fact for their claims. And that's a lower standard of proof than the ordinary balance of probabilities, or in the U.S., preponderance of the evidence standard that applies to ordinary civil actions. And if class actions were restricted to serious claims, I think the low threshold to certifying class actions would be quite justifiable. However, what has happened over the years has, in my view, distorted the class action objective. In these class action cases, the lawyer usually takes the case on a contingency basis and funds the action. And when the plaintiffs recover, either through settlement or a judgment, the lawyer takes a percentage of the recovery, perhaps 25 or 33% of the total. And that is said to be justified because the lawyer has assumed the risk in financing the action for the plaintiffs. The problem is that now many class actions are started really for the benefit of the lawyer, not for the actual plaintiffs. So if the telephone company happens to have assessed a charge for a service it wasn't providing, a subscriber might be charged 50 cents or $1 a month unjustifiably. Lawyers find out about these circumstances and then find a subscriber and start a class action. In the aggregate, the settlement sought would be worth millions of dollars, but for each individual member of the class, it may be $5 or $10. Now, when the action is certified, the corporation has a very strong incentive to settle because of the potential exposure if it loses the case. And the lawyer acting for the class plaintiffs also has an incentive to settle because the lawyer has financed the case and wants to reduce his or her risk and move on to the next case. And so the settlement may be for a fraction of the total claim. But if the total claim is $10 or $20 million and the settlement may be for, say, $3 or $4 million, the lawyer will walk away with $1 million or so. Well, what about the plaintiffs? They will often get nothing because the costs involved in distributing a few dollars to thousands of subscribers will exceed those few dollars that each might be entitled to. And so in these cases, very often the proceeds don't go to the plaintiffs at all, but go to a charity under what is called the Cypre doctrine. So you can see that this important process of holding corporations to account is at risk of being abused. While the function of class action should be to provide harmed individuals with an efficient process by which they may receive an appropriate result, in some cases, counsel are generating claims where the amounts recoverable are minuscule and the interested party is essentially the lawyer himself or herself. Such actions, in my view, distort the intended purpose of the class action process and exploit the low standard of proof at certification. In a class action case a few years ago involving Microsoft, I included sentiments to that effect in a couple of paragraphs that I had written. When I circulated the reasons to the other judges for their comments, 2 judges came back and said that if those 2 paragraphs remained in the judgment, they would refuse to sign on. They said that the two objectives of class actions were to provide access to justice and behavior modification of corporations, and they were not prepared to endorse the concerns expressed by me. On the other hand, I had colleagues who agreed with those paragraphs and wanted them to stay in. Well, it's easier to get agreement to delete. At the Supreme Court, you realize early on that you have to put some water in your wine if you want to end up writing for the majority. I'll next turn to the role of the courts in punishing corporations for actions the courts consider egregious. A 2002 case called Witten versus Pilot Insurance Company dealt with an award of punitive damages arising out of an insurance claim. The facts of the Pilot case are really interesting in their entirety, but I don't have time to go through them in detail, but you won't have any difficulty understanding what took place from what I will tell you. Daphne Witten, the plaintiff, owned a home in rural Ontario where she lived with her husband, daughter, and some pets. The home was insured under a homeowner's policy issued by Pilot Insurance Company. Mr. and Mrs. Witten discovered that their house was on fire as they were getting ready for bed after midnight on January the 18th, 1994. They fled their home along with their daughter, wearing only their night clothes, into a night temperature of minus 18 degrees centigrade or above 0 degrees Fahrenheit. Their 3 pet dogs escaped the building, but their 3 cats died in the fire. Keith Witten suffered a serious case of frostbite for which he was treated at the local hospital. He was confined to a wheelchair for 2 weeks. The fire totally destroyed the Witten's house and contents, including a number of valuable antiques and many items of sentimental value. The origin of the fire was never determined, but everyone who investigated the fire in the 6 months after it occurred concluded that it was accidental. This includes Pilot Insurance's independent insurance adjuster in 2 separate inquiries, another insurance adjuster after the previous one was fired, the Insurance Crime Prevention Bureau, and an engineer. I'm leaving out a number of other steps taken by Pilot, none of which established anything other than that the fire was accidental. Nonetheless, Pilot denied the claim and insisted the fire was started by arson, partially due to the Witten's precarious financial situation before the fire. Following the trial, the jury assessed damages against Pilot for the loss suffered by the Wittens of $287,000 plus a $1 million award of punitive damages. I know to those of you who are Americans, that's paltry sum. But in Canada, $1 million is, even in Canadian dollars, a lot of money. Normally, where a court upholds a plaintiff's claim for having been harmed by a defendant, the court will award compensatory damages, an amount that would put the plaintiff back in the position he or she would have been in but for the harm caused by the defendant's wrongful conduct. But on rare occasions, a court may award what are termed punitive damages. The purpose of punitive damages, as is apparent by the terminology, is to punish the conduct that could be characterized as malicious, oppressive, and high-handed that offends the court's sense of decency. The issue before the Supreme Court in Pilot was whether the plaintiffs had been entitled to punitive damages against Pilot Insurance, and if so, whether the extraordinary amount awarded by the jury, more than 3 times the actual loss suffered, was justifiable. While punitive damages are controversial, the amount of punitive damages awarded is often determined not in relation to any loss suffered by the plaintiff, but as a function of the amount necessary to act as a deterrent to the particular defendant. In other words, the same conduct from 2 defendants might result in much different awards of punitive damages, larger against the one with more resources, simply to ensure that that defendant felt the sting of the punishment sufficiently. Well, the Supreme Court found that the jury's award of punitive damages of $1 million was a rational response to the facts as, and I'm quoting, the jury was obviously incensed at the idea that Pilot would get away with paying no more than it ought to have paid in the first place. The award answered a perceived need for retribution, denunciation, and deterrence. End of quote. And finally, the majority considered whether the extraordinary amount of punitive damages awarded of $1 million was justifiable. And the Supreme Court held that this was an exercise in examining the proportionality of the award of punitive damages to the blameworthiness of Pilot's conduct, the vulnerability of the witness, the harm or potential harm that was directed toward the witness, the need for deterrence, and the advantage wrongfully gained by Pilot, all of which needed to be considered. While the court considered that the award of $1 million in punitive damages was very high, it was not so disproportionate as to exceed the bounds of rationality. In the result, the jury's punitive damage award was affirmed. Well, the law concerning punitive damages applies to all defendants, not just corporations. But Pilot Insurance nonetheless serves to highlight certain issues particular to corporate actors. The first point to note is that the court appeared to affirm that punitive damages properly operate as a disincentive to corporations that might view themselves as held only to the strict letter of their basic contractual obligations. Among the arguments made by Pilot was that insurance corporations should be fully entitled to approach claims with a high degree of caution, and in fact that a failure to do so may result in unmeritorious claims being paid out, with the result of higher insurance premiums for all. A similar theory might suggest that any corporation is not only entitled to approach claims as cautiously as possible, but is actually obligated to its shareholders to do so, lest it incur any more expenditures than absolutely necessary. By drawing a distinction between due diligence on the one hand and what the court called willful tunnel vision on the other, the court set a limit on the extent to which corporations may privilege the interests of their own bottom line at the expense of those with whom they have commercial dealings. And in doing so, the court can be seen as signaling 2 things to corporations and their shareholders. First, shareholders' reasonable expectations must include that corporations will honor not only the technical requirements of their contracts, but that they will also conduct themselves as reasonable commercial citizens, honoring obligations of good faith and fair dealing where they arise. And second, in order to ensure that corporations meet these obligations, the courts are prepared to sanction significant disincentives for contrary behavior. In other words, the courts are prepared to actually make adherence to the standards of reasonable commercial conduct cost-effective by creating significant negative effect on bottom lines where unreasonable conduct is found, effectively saying to corporations, you can tell your shareholders that you have to behave because it might cost them if you do not. Second aspect of Pilot is how it once again reflects the Supreme Court's apprehension regarding the disproportionate power held by corporations in society and willingness to craft tools to rebalance that power. The court noted a number of points in this regard. The the fact that Pilot Insurance was in the business of selling peace of mind, that the corporation had held itself out as a guide to safe harbor, and that Pilot Insurance was required to behave appropriately with recognition of the fact that the more devastating the loss, the more the insured may be at the financial mercy of the insurer, and the more difficult it may be to challenge a wrongful refusal to pay them. The court held that in the circumstances, the Witten's peace of mind should have been Pilot's objective, but instead it exploited the plaintiff's reliance and vulnerability in the hope of starving them into a cheap settlement. Well, in some respects, these are extraordinary statements. The suggestion that the Witten's peace of mind should have been Pilot's objective in particular is somewhat difficult to reconcile with normal commercial reality. On the contrary, commercial reality is at some level all about acting in self-interest and exploiting vulnerabilities. But Pilot Insurance reflects the fact that both juries and judges retain some level of discomfort with the unchecked pursuit of self-interest by corporations and are prepared to set limits where extraordinary vulnerability, as opposed to what I'll call ordinary vulnerability inherent in the marketplace, exists, particularly where it has been created by the very nature of the product offered by the corporation. I'll next speak about tobacco advertising and corporations' relations with the government and inferentially the public interest. In a case called J.T.I. MacDonald in 2007, the Supreme Court considered the issue of advertising in the tobacco industry. I did sit on this case, so you can't criticize. Seriously, the issue before the court was whether certain restrictions on advertising in the Tobacco Act and the tobacco regulations violated the rights of tobacco manufacturers for freedom of expression guaranteed under the Canadian Charter of Rights and Freedoms. Well, more than a decade before the J.T.I. MacDonald case, the Supreme Court had struck down legislation that imposed a blanket prohibition on all advertising and promotion of tobacco products on the basis that it unconstitutionally infringed on the tobacco manufacturer's freedom of expression. In response, Parliament drafted new legislation, and that's the legislation that came up in JTI. And the tobacco manufacturers challenged in that case this new legislation on the same basis, that it constituted an unconstitutional restriction on their freedom of expression. Those of you who are Canadians will already know this, but I'll start with a brief overview of the framework of the Canadian Charter upon which the tobacco manufacturers relied in their challenge to Parliament's tobacco advertising restrictions. The Canadian Charter of Rights and Freedoms sets out certain rights, including freedom of expression, freedom of religion, freedom of association, but we're dealing here with freedom of expression, that are constitutionally guaranteed in government action and legislation, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. And that caveat, known as the saving provision, is found in Section 1 of the Charter and effectively acts as a restraint on the absoluteness of the rights otherwise recognized as being guaranteed. To be demonstrably justified, the law must have a pressing and substantial objective. The means and effects of achieving that objective must be rationally connected and proportional, and the charter right should be as minimally impaired as possible. Only where a law both restricts a charter right, like freedom of expression in this case, and does so in a manner that is not demonstrably justified, is it considered unconstitutional. And where that finding is made, a typical remedy is to declare the law of no force and effect. In J.T.I. MacDonald, the Supreme Court determined that restricting advertising appealing to young persons was justified, since the expression at stake, tobacco and brand information, was low-value expression. Restricting lifestyle advertising that associated tobacco with glamour, recreation, excitement, vitality, risk, or daring was justified due to the benefit derived from preventing increased consumption and addiction, and once again reiterated the low value ascribed to this form of expression at issue, and banning the industry's sponsorship of athletic and cultural events was justified for the same reasons. Throughout its analysis, the Supreme Court incorporated comments regarding the social context in which the advertising restrictions at issue were being imposed. Most smokers begin as teenagers between the ages of 13 and 16. Tobacco advertising serves to recruit new smokers, especially adolescents. Tobacco advertising has three objectives: reaching out to young people, reassuring smokers in order to discourage quitting, and reaching out to women. The creative ability of the manufacturers to send positive messages about a product widely known to be noxious is impressive. In recent years, for example, manufacturers have used labels such as additive-free and 100% Canadian tobacco to convey the impression that their product is wholesome and healthful. Technically, the labels may be true, but their intent and effect is to falsely lull consumers into believing, as they ask for the package behind the counter, that the product they will consume will not harm them. Given the sophistication and subtlety of tobacco advertising practices in the past, Parliament cannot be said to have gone further than necessary in blocking advertising that might influence young persons to start smoking. Well, J.T.I. MacDonald offers some insights on how the Supreme Court conceives of corporations and their role in society. The Court emphasized at every turn that the expression at issue in this case, advertising intended to benefit the corporation's bottom lines by drawing in additional consumers, was of low value. Well, this is significant because the protection conferred by the Charter is supposed to be content and motivationally neutral. The Court's position appears to be that commercial expression is protected, but where the expression is used to promote products that may be harmful, restrictions on that commercial expression will be easily justified. Taken to its logical extension, this suggests that those who promote products viewed by the government and the courts as being beneficial to society will enjoy far greater freedom of expression in their ability to promote than those whose products are viewed as harmful and at the expense of the broader public. An understandable approach, perhaps, but perhaps also doctrinally weak. And I say that in a tobacco case, it seems pretty clear. But there can be other cases that are closer to the line between what is beneficial and harmful. And finally, because this is an international conference, I'll turn to one subject that has some bearing on international corporations, and that is the subject of transfer pricing, but I'll be mercifully brief. You all probably know that transfer pricing relates to the prices for products or services paid by one entity of a multinational corporation to another entity of the corporation resident in a different tax jurisdiction. Because these entities do not deal with each other at arm's length, their transactions may not be subject to ordinary market forces. Non-arm's length dealings are between parties that are related or that are otherwise on close terms. The transfer pricing provisions in legislation are aimed at precluding the transfer of taxable earnings from the jurisdiction where they appropriately belong to a lower tax jurisdiction, often by the payment of inflated prices for goods or services to a related corporation resident in the lower tax jurisdiction. Canada uses residence as the connecting factor to establish taxable nexus. The obligation to pay tax on the basis of residence derives from the principle that persons who benefit from their economic and social affiliations with a country have an obligation to contribute to its public finances. The Supreme Court has decided only one transfer pricing case, even though transfer pricing legislation has been on the books for over 70 years. The case we decided involved the pharmaceutical giant GlaxoSmithKline. In the early 1990s, Glaxo Canada, a subsidiary, purchased ranitidine, the active ingredient in an anti-ulcer drug marketed under the brand name Zantac, from Adesha, a Switzerland-based related party. The combined effect of both a license and a supply agreement between the parent company and Glaxo Canada allowed Glaxo Canada to manufacture and market the final product under the trademark Zantac. Glaxo Canada paid Adesha $1,500 to $1,600 per kilogram for ranitidine. At the same time, two Canadian generic companies purchased ranitidine from different sources for their generic anti-ulcer drug for $200 to $300 per kilogram. Canadian tax authorities compared the prices paid by Glaxo Canada with the prices paid by the generics and reassessed Glaxo Canada for the difference. The result was an amount of tax of some $51 million. The government's position was that the prices paid by the generics reflected what parties dealing at arm's length would pay. The question was whether the licensing agreement was relevant in determining whether the prices paid by Glaxo Canada to Adesha was reasonable, and if it was relevant, was the price paid by Glaxo Canada the same as an arm's length purchaser with the same supply and licensing agreements would have agreed to pay. The government argued that the OECD guidelines with respect to transfer pricing should be determinative, and that a transaction-by-transaction approach, considering only the supply agreement and comparing the impugned prices with arm's-length prices, was appropriate. However, the guidelines take business and economic realities into account to ensure that the two transactions are sufficiently comparable. The Supreme Court found that in this case, that meant that the license agreement had to be taken into account in addition to the supply agreement, and simply comparing prices paid by the generic companies with the prices paid by Glaxo Canada was not appropriate. Ultimately, the case was remitted to the tax court, where, and finally, I understand it was settled out of court. Well, in comparing arm's length and non-arm's length transactions, pricing is not an exact science, and leeway has to be made for a reasonable range of arm's length prices. The functions and risks and assets of a Canadian company as compared to its multinational relation had to be taken into account. Arm's length prices had to consider the independent interests of each party to the transaction. In this case, the ability to market under the trademark Zantac or reliance on the quality control or reputation provided by the Adesha product may have made the higher prices reasonable. But having found that governments are becoming very aggressive in pursuing transfer pricing cases, corporations will be under severe scrutiny to ensure that taxes payable reflect an appropriate calculation of a corporation's earnings in the jurisdiction where they are actually earned. Well, I'll conclude by telling you that as a Supreme Court judge, I had some unique experiences. About 5 years ago, I was invited to judge a moot court between Sir Robin Jacob, then recently retired as a judge of the English Court of Appeal, and Lord Hoffman, recently retired from the then House of Lords. It was a patent case involving a coated stent for insertion in coronary arteries for after angioplasty. Before he retired, Lord Hoffman and the House of Lords had reversed a decision of Lord Justice Jacob in the Court of Appeal. The two judges agreed to re-argue the case themselves at University College London, and they asked me to judge it. Both judges are highly respected intellectual property experts. When I received the invitation, I said to Sheila, "Did you ever think in your wildest dreams that I would be judging a moot court between two world icons of intellectual property law?" And she said, "Marshall, you aren't in my wildest dreams." Thank you for your attention.